everyone who's present here. I'm Nita Pillai, the moderator for today's session, which is organized by LawInternships. I heartily welcome you all. We have among us Advocate Smeeksha Pandey, ma'am.
Good evening.
Good evening, ma'am. Ma'am has completed her undergraduate BA LLB honors specialization in IPR from Amity Noida. She went on to practice in Indore High Court. She did her master's from Hidayatullah National Law University, Raipur in IPR. Ma'am has pursued certified courses in from IALM Delhi, courses from Harvard EDX on justice and children's rights. Ma'am is currently, yeah, Ma'am is currently practicing in the Delhi High Court and Honorable Supreme Court, mainly civil matters. She practices in the specialized field of family counseling and mediation. She is a council member at Women's Indian Chamber of Commerce and Industry. We welcome you, ma'am. Ma'am will be discussing on how to draft and file legal notice. If anyone has any queries, questions, you can raise your hand and we shall recognize you and unmute you, or you may write your question in the chat box. In the end, the floor shall also be open for any questions. Just to make the meeting more interactive, let us all switch on our cameras. So without any delay, let us further begin the session for today. Over to you, ma'am.
Good evening to one and all present here. It is a very good opportunity for me to be here and discussing about the nuances and the various detailings of drafting. So drafting is an art, I must tell you this. Drafting is something which comes with practice. It doesn't come naturally because if you see a draft, the first notice or even an application, if you are drafting, you will see that with every application you will be improving over it. And when we talk about in legal sense, so drafting in legal sense means an act of preparing legal documents like agreements, contracts, sale deeds, etc. So basically when you are in legal drafting, you will see that the most important part about drafting is knowing the facts of that case well, because a good draft is considered as a story. It don't has any hitches, it don't has breaking points, it doesn't have any jumps in between. You have to be very careful about the dates which you are writing. So when you are drafting, it's more of like you have to consider it like a script writing, that okay, you know, an incident which was narrated to you by your client, and now you have to like express it in legal terms and something which the court can understand. So drafting is not something which you will be expert at in the first go, or maybe in the first year of practice also, if I may say, because every draft needs some different kind of approach while writing it. You will need some research in some draft, like application. When you are filing, you will be needing precedents to uphold your point in your application. So every draft has a different kind of challenge, and in particular I will be dealing with three kind of drafts to discuss that okay, what kind of challenges those drafts can have. So if you see that a proper understanding of drafting cannot be realized unless the nexus, that is a connection or series of connection linking two or more things. So if you see a situation where a client has come to you, now he and she will give you an uphold of an incident, what has happened to them over a period of time, maybe, or over a series of events, maybe, and you have to see that how you can join all those incidents, which is also known as, in legal terms, if you hear, it is also known as corroboration of events, that you have to corroborate each event with the other and see that how this story will be projected when you will be putting up in front of a judge. So for this, you have to see all the documents which the client will be giving to you. You have to hear the story once or maybe more times, and then you have to do a thorough research. So in order to be good at research, you have to know the facts well. Because if you are not well aware about the facts and you miss on detailing or those legal angles which are important, then your research might not be good in that particular case. So you have to know how the facts have to be put up on a same page. You have to have some precedents supporting your case, and this is how. And then these first two steps, when you have cleared and suffice their needs completely, then you will start writing something. Because in drafting you need to have a lot of knowledge about the facts, about what you should be writing, how you can express it, and how you will be projecting it. Because if you see in civil matters, drafting plays a very important role, because you cannot go beyond what is written in your file. So if you are leaving on points, if you are leaving on incidents, dates, and you have not corroborated the events well or written well, then it might be that your case, even though being a strong case, you might lose over it on the point of drafting. Because what you have not written, you cannot prove in the court, or what evidences or documents you have not put in your file, those you cannot express at later stage. So drafting may be defined as the synthesis of law and fact in a language form. As Robinson drafting its application to conveyancing and commercial documents. So the process of drafting operates in two planes, the conceptual and the verbal. So the concept, as I have already discussed, that the conceptual part is very important, that you are thorough with the facts, you have well researched that what laws will be applicable to it, and you are ready to write it well. Because see what happens nowadays, that the formats are available online and everyone is downloading those formats, whether it's a sale deed, whether it's a application, whether it's a notice. But you have to keep in mind that it should satisfy your case, it should satisfy your point, and you should be able to express your point through that format. So you have to be very specific when it comes to drafting. So besides seeking the right words, the draftsmen seek the right concept. Drafting, therefore, is first thinking and second composing. Because you will need a lot of work in thinking how to go about it, not be repetitive, be very expressful, be mindful about the words you are choosing. So there are some laws relating to drafting, and let's see which are those laws. That is the Constitution of India, the Companies Act, Indian Evidence Act, Family Law, Indian Contract Act, Registration Act, Transfer of Property Act. And these are some laws that is mostly of civil nature, which requires heavy drafting and a lot of drafting. Let's see how many types of drafts are there. So firstly, let's see what is a deed. So a deed is an instrument. Basically, if you are not well aware about a deed, then I must tell you that it is more of a civil legal document which is executed by some person or corporation, or consent, or giving assurance interest in some property or subject matter. So, like you have sale deed, contract, and these kind of deeds are filed. So, if you see that the draft which are verified, and the draft which is also known as a document, has been expressed in Section 3 of the Indian Evidence Act, which defines a document that is any matter expressed or described upon any substance by means of letters, figures, marks, intended to be used for recording that matter. I hope I am clear and audible.
Yes, ma'am, you are.
Okay, let's go ahead. and see what are the importance of contracting parties and what are the valid points on which contracts are made. First is the subject matter. The subject matter of the agreement must be described in detail, giving its precise situation and the extent of interest agreed to. So basically, when you are making starting with a draft, you have to be very thorough with the subject matter on which you are drafting. For example, there is a matter related to maybe recovery of money or recovery of money. So you have to be very thorough that when you have given the money, if there was any interest on it, and you discussed about that interest with the other party, or if you have any actionable claim on that. So you have to see what all is required for that, and what are the important points which you have to mention in the subject matter. Then you have to go with the time of performance, that if the time for performance is the essence of the agreement. For example, I must tell you about actionable claims. What happens? So there is a movable property and immovable property under transfer of property act. So Transfer of Property Act basically deals with immovable property, but the topic I am taking is actionable claim. So actionable claim happens on movable property which are under possession. So time for performance become a very important part of that actionable claim. So, for example, somebody came to me, my friend came to me, and she said that I need some money. Oh, I said, okay, tell me how much. She said 1 lakh. So maybe I may take something in return of 1 lakh, or I don't. Now let's discuss these two cases, that when I take something in return, like for example, I say that, okay, this is a huge amount. So give me something, a collateral in return, so that if you are not able to pay the money later on, then I can use it in order to not be in loss. So, for example, if she has a car of 5 lakhs, she gives it to me. That okay, I am taking 1 lakh from you, take my car, and until I haven't returned the money, I won't be taking the car. So in that case, I cannot claim anything. So my claim doesn't work in that case. For but in the other case where I have not taken anything from my friend in return of money, then my actionable claim arises, that okay, now I can claim money which I have given to her. So in that case, the time for performance become very important, that okay, I gave money at this time or this date, and then I gave her notice or reminders to return me the money, but she was not able to. So now I am claiming my action. Let's come to other topics, that how we can go ahead with writing legal notice. So a legal notice is generally filed in civil cases, because in criminal cases there is no filing of the legal notice, as in case of a criminal offense the action is instituted by the state against the person committing the offense. So however, if you intend to initiate a civil suit against the government, you have to serve a legal notice to the government beforehand, and only thereafter you can file a civil suit against the government. So, if you are aware, Section 80 of the Civil Procedure Code 1908 provides for sending of a legal notice to the government or public officer if one wants to initiate a legal notice. And if you have read about this case, Bihari Chaudhary versus State of Bihar, Supreme Court has stated that the object of the section is the advancement of justice and securing of public good by avoidance of unnecessary litigation. So when you are giving a legal notice, basically, so you are giving the other party some time that they can act upon and think about that what they have to do. For example, if I have taken money and I am not returning, so first that the other person will remind me that okay, you have taken Smeeksha this much money and I think you should return, and it's high time. But if I am not returning it, then the other person, before filing a civil suit or before filing a case against me, will be sending me a legal notice through their advocate. And even then, if I don't pay any attention to it, then they might go ahead with the litigation. So if you see essentials of section 80 of CPC, what is the basic requirement of a notice? Name, description, and place of residence, statement of cause of action. Now, when I say cause of action and subject matter, they are somewhere similar because you have to explain your part of story in that. That how does this cause of action arise, or how your claim is arising, and you are therefore coming forward with this legal action. Then the relief claim by the sender of the notice. So this is very important. See, sometimes you see that the clients come to you, they are so hurt and so angry that they just want a revenge, and they are not up to the mark in thinking that what exactly they want. So you have to be very clear with the relief you are claiming for. That you want a recovery, you want a punishment, and accordingly a case will be filed. If there is a recovery case, that there is a case of money, and you want that a person to be punished for that money, then I don't think that you will be taking a right approach towards it. Okay, so you have to be very mindful that it is a civil matter or a criminal matter, and what kind of application you will be filing. And then the fourth and the very important point is summary of the legal basis of the relief claim. And in this you have to basically define from day one to everything which has happened, and now today you are standing at this point writing this. So, drafting can be very boring sometimes. But then, if you want to be a civil advocate or a civil lawyer practicing in the court, then you have to be well versed with drafting. And it is always a learning process. I think with each draft, you will feel that you need more improvement, you need to do better research. So, it's a never learning process. Let's discuss a few other legal notice, easy ones. Let's take Section 138 Negotiable Instruments Act, because this is very common. And in the case of a check bounce, it is mandatory to send a legal notice. That's why let's take this first, because you cannot file a case in a check bounce until you have sent a legal notice to the issuer of the check within a time frame of 30 days from the date of check bounce. So if no repayment of money is received after 15 days of the delivery of the legal notice, then you can initiate a legal action within 30 days from the date of completion of 15 days time period. So when I am saying from of 30 days, received after 15 days, then date of completion of 15 days. So these are very important limitations which I'm talking about, and which are very important in the complexity of drafting. If you are delaying in this, then you have to file a delay of application, and you have to talk about the reasons that why this delay was made. So filing, you just cannot go on filing any application, any notice, anything whenever you want to. You have to be thorough with your limitation act, that till when your right was there, and till at which date your right of filing any notice or application relaxed or got hindered. So criminal liability is also established under this section, wherein the drawer of the dishonored check may get a sentence of 2-year jail terms or fine or both. So in the notice, you have to provide details of the transaction for which the check was issued, details of the check, details of dishonor, etc. through a lawyer. Notice to be signed by both the lawyer and the payee, and notice to be sent through registered post. So for section 138 of the Negotiable Instrument Act, how to draft a notice. So a legal notice is essentially a notice sent by an advocate on behalf of his or her client. It is not mandatory for a person to send a legal notice through an advocate. So if you just have to send a legal notice, you can write it in your own words as well and send it, that if within 15 to 30 days, if you don't get a reply, then you will be initiating your legal procedures and seeing what legal rights you possess. So it is not even mandatory to send a legal notice, as there is no specific provision enactments of law that make it mandatory to issue a legal notice before filing a suit. But it is important because when you go to the court, then the court will ask that what did you do in order to reach out to that person. So in that case, legal notice becomes a very important step, that you will say that, okay, I sent legal notice, I sent reminder, but there was no reply. So hence I am in the court of law seeking for justice. So a legal notice is generally issued by an advocate and for soliciting a settlement. So it is issued either to accept the settlement or to reject it. I hope I am clear.
Yes, ma'am.
Okay.
Yes, ma'am, you are.
Let's see few more details. For example, if you are going in a sale deed, so in a sale deed, you will be approaching these kind of drafts differently. You will be talking about the parties involved in the sale deed, okay, which was not important in negotiable instrument notice because you just have had to talk about the check, the contract, and why the check got dishonored, okay. But in sale deed, you will be talking about the parties involved in the sale deed, and this clause contains the description of the parties to the sale deed, that is vendor and vendee when we talk about. Then description of the property, that what forms the detailing of the property and what is the major property which is involved in the sale deed. So in the sale deed, there is a clause that informs the parties specifically about the dimensions of the property being transferred, that what is the length breadth of the property, that is a detail of the property, like the measures of the plot in yards or meters, the length of the property extending in which direction, and the carpet area and all. Then third becomes the third point, which is important for sale deed, is the sale consideration. As a buyer or seller of a property, one of the most important and primary factors is the price at which the property is bought or sold. So invariably, price at which the deal is closed is called consideration. So the clause reads out the price at which the land is being transferred and that it is agreed upon by the parties to the deal. Then fourth is the clause regarding payment method, advancement payments or installments, how the payments will be made. And then as we go ahead, so I'm telling you the titles, that how a sale deed is basically typed. So if you know the titles, you know what you will be putting it in it according to your facts. So transfer of title clause, delivery of the deed and possession of the property, indemnity clause and encumbrance clause. So these are few things which you will be keeping in mind while drafting a sale deed. So see, from notice to sale deed, you have seen how what are the different criterias every draft is required. So there is no standard format when we are talking about drafting. See, a simple notice, a simple legal notice just requires facts. Then we discussed negotiable instrument acts, so we went into its details. Then you have seen that sale deed requires more detailing of the case. So it basically keep on changing from case to case, and I hope this was clear to you. Let's see if there are any questions ahead and what all you want to know about this topic. So are there any questions till here? Let's take few questions and then move ahead, because I have only one draft to discuss more.
Interns, is there any questions from ma'am? You can ask her.
Ma'am, it is clear from my side.
Okay. So let's discuss one of the last drafts which I kept for today, and that is terms and clauses of a contract, because many people are in commercial law and we draft contracts on daily basis. So let's see the few are which clauses are important for a contract. That is subject and its legality. That the reason why this contract is being formed. The first and foremost place to begin the drafting of a contract is to determine what the subject of the contract is. That is, you are coming in a partnership, or it's a company, or it's an agreement for something which is a time barred agreement. So the subject of the contract will also determine if the contract will be legally enforceable or not. If the subject matter is itself illegal, then the contract will not have any legal validity. Then the definition clause, that when you mean something, what it is. Each and every contract must consist of a definition clause. Such clause contains all the definitions to various words that are used throughout the contract, which is related to your work space. Certain words holding a general meaning may be used throughout a contract, but the contract may contain a definition of such words which might describe the meaning of such words specifically. Then term of contract, that contracts are generally made for a definite period of time, no matter how long the time frame may be. So the term consists of a specially stated time period during which the relationship between the parties will be governed by the terms of such contract. And once the time period expires, the contract automatically dissolves, and you can always renew the contract. Then clause of renewal of contract, because when you are coming to renewal of contract, you might modify some clauses as per the time and situation which is in your hand. Then the consideration amount and legality, that another important clause in a contract is the clause stating the amount of consideration. It states the consideration amount that one or more parties must pay to the other party for service done or good produced by the latter. Then inspection of products and goods, in case the contract is about sales or goods. And then return, refund, dispute settlement and jurisdiction is the most important clause, because mostly nowadays, if you will see, then mediation, arbitration or negotiation becomes a very important clause of the contract if you want to go for a future settlement and jurisdiction and take ADR as a way of solving the problem. So with this, I end here. These were few documents and drafting I kept for discussing. I hope it was helpful.
Yes, ma'am.
The floor is open for question answer. If any one of you has any further questions, you can ask from ma'am.
See, when we are drafting a contract and we are including an arbitration clause in it, then it becomes binding, because you then later on, a later stage when there is a problem or a conflict, then arbitration is the first stage where you will go, since it is already mentioned in your clause, in your contract. So we take this clause into consideration very seriously. Yes, see, use of words like may and shall are very important, and basically, this becomes important when you are drafting your application uh, for some evidentiary value. Then these kind of words, usage of words, become very important. That where you will put and how you will express.
Interns,
Any further questions do you have?
Your next assignment will be based on legal notice. So if you have any kind of queries, ma'am is here now, so you can ask her.
Ma'am, I have one question.
Yeah.
Ma'am, just like ma'am told it, our next assignment is on which is based on a legal notice. So, ma'am, I haven't write any legal notice. So, ma'am, can you please tell me that how we can we start and what are the things we can include in it?
See, if you want to go with your first draft, then I will suggest to go ahead with maybe a consumer forum application or a consumer complaint. It will be an easy way to start that, okay, you bought something which didn't work and it has its guarantees still going on. So how you can claim a right over your consumer product. So for starters, you can go for a legal notice, maybe that recovery of money, or legal notice for extension of time period of recovery, or then Negotiable Instrument Act application is the basic one, and consumer forum app, complaint.
Okay, ma'am. Thank you, ma'am.
Any more questions? If there's any doubt, any query, you can ask ma'am.
You can also write to me on my email address later on if there is any doubt, and I'll address to it as and when I get time.
Yes, ma'am. Can you please write your email
Yeah.
on chat box?
So ma'am has mentioned her email on the chat box. You can stay in touch with her. You can send your queries on her email also. So thank you so much, ma'am, for such a good session. Thank you for brushing up everything. So further, I would like to move with word of thanks. I, Nitya Pillai, on behalf of Law Internships, would like to extend my heartfelt gratitude to Ms. Sameeksha Pandey, ma'am, for taking out time from a busy schedule and interacting with young minds. It was truly an enriching session. Thank you so much, ma'am, and thank you so much, everyone, for joining here.